So this kind of PIL we are already seized with.
Yesterday it was listed.
Yesterday it was there.
In fact, more than 2.
Ah, all relating to implementation of this Right to Free and Compulsory Education Act 2009.
In this PL, my lords, I have been challenged the GO 25, which allows the single schools in across the state of Telangana. It is ultra virus.
As being opposed to the Right to Education Act.
As maybe it is with that only, my lord, but the GO is separate. It is GO number 25
Of which year?
in 2021, my lords.
Where are we now?
My lords, it is continuously affecting the people.
See, for the past 4 years, the GO was in vogue.
Yes. Yes, my
What are
lords.
the difficulties that any person has come across on account of that GO in these 4 years?
The effect is, my lords, it is 5,000 schools are running in the state of Telangana. Almost 1/4 of its total strength has been running with the single school. If we look at the statistics,
On what basis are these statements made? What is the basis for these statements? 5,000, 6,000?
yes, my lords, it is a
What is
US
the basis, sir?
UDSE data which is published in the national websites, my lords.
You placed along with the writ petition.
No, my lords.
Stated in the writ petition.
Yes, my lords, I have been stated.
Without that data, we will not be able to appreciate, is it not?
My lords,
Without that data being made available,
my lords, here it is a purely question of law, whether it is ultra virus or not.
it is also
The
a
Parent
question of
Act-
fact.
My lords,
It's also a question of fact
before we
whether 5,000 schools are working in the state without complying with the provisions of the Right to Education Act
yes, my lords.
by having a single teacher, violating
Yes.
the teacher-student ratio is also a question of fact.
That is a question of law also, my lords. In the act, it is very clearly specified that 0 to 60 people. It
Your
should be-
statement at paragraph Roman 6 on that issue or fact is not supported by the statement that you have obtained this data from some Government of India website.
I have not mentioned, my lords. I have
So
not
therefore, when the
You don't
Lordship asked
furnish
the que-
data, you don't state the source of the data.
My lords, it's a, now I am questioning this, the GO number 25 ultra virus. Whether the government has to be come forward with what is the exact number it is having right now.
Have you
output,
made any representation to any authority?
I did not, my lords.
Then-
That is the reason why they are, I have been, I am filing a
without
memo,
without making any representation to any authority,
my lords.
can you simply rush to the court with a PIL?
Yes, my lords, in the regarding the same, Apex Court has been clearly stated that when it is a question of the ultra virus, when it is a question of the fundamental rights, it is exempted by the availing the alternate remedies. Honorable Supreme Court 3 times in the recent last 2 years, it's a 3 times has been given the same direction. I have-
Notwithstanding the fact that the GO is of 21 and the public interest litigation is being filed in 2025. Notwithstanding
Relax,
the
there
fact
is
that the
no
public
any
interest
statutory
litigation,
bar to when the GO has been issued. The GO is not available for the public also. That is a one more question. It is kept in the secrecy. Now also the government is GO not made available in the official website. They are kept in the darkness.
sir, you can't make statements about GOs being kept in the dark in this age of information. Have you
Yes.
made an application under the Right to Information Act?
I'm not did me lords.
Then-
And it is not the bar to file a PA.
Non-statement of the source of information is a bar?
I am presently challenging the GO whether it is consistent with the law or not. The information is gives the in the following course of the adjudication, the information will be valid for us. At this point of junction, whether this petition has to be entertained or not. Lords.
The registry has raised an objection saying that
Yes.
there is an alternative remedy available.
Yes, my lords. Further regarding only, my lords, I have been filed the memo along with the Messer Godrej Sara Limited versus the Excise and Taxation Officer in the year 2023 February.
Where is that memo?
I have been forwarded. my lords.
You have handed it over now
Yes, my
to the
lords.
bench.
Yes, my lord.
This you ought to have done in the registry, is it not?
I have been discussed with the registry.
You can't discuss with the registry.
I have been taken a copy also, my lord, but they're not accepting. You go and directly.
Registry has returned your petition with an objection. You are supposed to comply with the objection with the answer and submit it back to the registry.
I have been submitted, my lord. They refused to take it, and they clearly.
Have you said that in your?
Yes, my lords. I have been went for the registry, the judicial one.
In the affidavit, have you said that registry has refused?
After that, when I have been filed, then after they call me, then after raised the objection, my lords. How it can be there in the affidavit, my lords? You can just check it once with the page number 880, my lords.
Where is the affidavit with regard to the research you have undertaken about the PIL spending? Which form is that in the affidavits?
My lords.
Under the public PIL rules,
My lords.
there is an affidavit which mandates a disclosure about the efforts that you have undertaken to find out about the pending PILs. Where is that affidavit?
Pending? Sorry,
the basis of your information and whether you have verified about any pending public interest litigations on the subject matter.
As of my knowledge, there is no pending PILs regarding the particulars of the Millards. It's the act is very wide, and there is several GOs are there. People will try to push on one particular GO. In this particular subject, I am challenging the GO 25. GO number 25 has been not challenged regarding to this situation.
It is not the number of the GO or the year of the GO.
Yes, Millards.
What is in challenge in the other public interest litigations is the teacher-student ratio, the absence of facilities under the Right to Information Act, the compliance of various other provisions of the Right to Information Act, Right to Education Act.
Yes, Millards.
Is your public interest litigation any different from any of these?
Absolutely, Millards.
What is different about this?
Millards, it is in the Act, Principal Act. Kindly come on to this page number, Millards.
What does the GO say?
Millards, kindly come into page number 34, Millards. 1 second. This is a schedule has been prescribed in the Parent Act, which stating that, Millards, for the first class to fifth class up to 60 people, it should be 2 teachers should be there. Very clear, Millards. And if we are look at the page number 38, Millards, in the page number 38, which is the annexure of the GO number 25, they are very clearly stating that redefined the slab 0 to 19, it is a 1 GST. And Millards, very interestingly, point number C of the same annexure, in the view of the large number of vacancies in GST category, only 1 GST is posted to 0 to 19 enrollment slab as to prevent the closure of the school for wanting of staff. It is a clear admission of the government where they are Act is clearly saying that the 2 students should be there. The central act, this
Sir,
is, yes,
Please,
one second.
please follow.
Yes, my lords.
There are other public interest litigations which complain of non-compliance of the teacher-student ratio as mandated by the Right to Education Act.
No, my lords. As of my research, there is none of PILs has been instituted in this court.
Then
So
your
far.
research is not proper. They were listed yesterday.
Maybe it is tagged with that same subject, my lords.
Sorry?
If that is there, you may tag with that. Now,
No.
now the
We don't need multiple
you may
public interest
direct. You may
litigations.
direct with the case numbers, my lords. We will verify once again. If it is true, we can comply with the orders, my lords. Here the question is, my
You
lords.
can't ask this bench to do your job.
Sorry, my lords. As per our understanding, my lords, it is not there.
Take down. Present PIL has been filed. Office has taken an objection that in the nature of directions or writ of mandamus sought in the present PIL, the writ petitioner has not filed any, approached the concerned authorities by way of making of a representation. Stop. The petitioner in person contends that since a GO dated 12th August 2021, bearing number 25, is under challenge, there is no need for making a representation. However, a perusal of the relevant paragraphs, relevant prayer, shows that petitioner also seeks direction to strictly implement the mandatory norms and standards prescribed under the Schedule 2, the Right of Children to Free and Compulsory Education Act 2009, including pupil-teacher ratio and adequate staffing in all government schools, for which, in respect of which petitioner ought to have approached the authorities first. Stop. It further appears from perusal of the statement made at para 6 that petitioner has asserted that there are more than 5,000 schools operating in the state of Telangana with a single teacher, despite being there no provision for single teacher school under the Act of 2009. This statement is not supported by any information obtained from any authentic source. Stop. On an overview of the matter, we therefore do not, we sustain the objection.
Acknowledged, my lords.
Raised by the registry.
Sustain the objections raised by the registry.